We're going to be talking about navigating the workplace, but we are going to be focusing on workplace fairness and discrimination and just knowing your rights as, as you guys prepare to enter into the workplace after graduating, having an understanding of what that is really important. And so we're really happy to welcome the EOC with us here this afternoon. And we have our speaker, Director of Legal Services, Mr. Haran Ramkaran Singh, and he is the Director of Legal Services at the Equal Opportunity Commission for Trinidad and Tobago. Mr. Ramkaran Singh leads the Commission's legal unit, whose primary task is to manage complaints from members of the public. Mr. Ramkaran Singh holds a Bachelor of Law degrees from University of the West Indies, so he's an alumni, a legal education certificate from the Council of Legal Education, and an international master's in business administration from the UWI Arthur Lockjack School. Mr. Ramkaran Singh has previously been employed as a corporate legal officer in the Corporate Legal and Compliance Department of the Telecommunications Services of Trinidad and Tobago, a legal officer too in the Legal Department of the Trinidad and Tobago Electricity Commission, and a legal officer in the Chief State Solicitor's Department in the Ministry of the Attorney General's Office. He was also a member of the Council of the Law Association of Trinidad and Tobago for 6 one-year terms. At these institutions, Mr. Ramkaran Singh gained a wealth of knowledge and experience in civil high court litigation, trial advocacy, public law and human rights, corporate governance, and regulatory compliance. So let's welcome Mr. Ramkaran Singh this afternoon. Take it away, and it's going to be a great session.
Hi, good afternoon. Thank you, Nandi, for that introduction. Good afternoon, all. We're here to talk about navigating the world of work and understanding concepts such as equality and discrimination and how they apply to you. It doesn't just only apply to you as a worker, but eventually, for example, when you graduate, you're going to start off as a worker, but hopefully, I would hope that over the years, you're going to move up. You're going to eventually become part of the management of the organization. Maybe you may even branch off into your own business or be involved in your own practice, whatever it is you're doing. So then you would probably be, for want of a better word, on the other side of the coin, thinking, well, how would you need to treat with persons who are coming into your organization? That's the one that you have. Also, when we're going to talk a little bit about sexual harassment, and one of the things I like to point out to that, harassment sometimes really speaks of how you relate to your co-workers. So these are the 3 dimensions I wanted to look at. You as the employee, what rights do you have with respect to your employer? Secondly, how do you relate to your co-workers? And then thirdly, when you become an employer, a manager, supervisor, you move higher, how should you treat with the persons who, as we say, your direct reports, the person who report to you? So with this in mind, we're going to go into our presentation. What I'm going to talk about, we're from the Equal Opportunity Commission. So I'm just going to speak for about 2 or 3 minutes about the Equal Opportunity Commission, who we are and what we do. Sorry, excuse me. Now, we were created by, and then I'm going to talk about what constitutes discrimination, so you'll understand what specifically is our mandate, because the concept of discrimination and equality is a very wide concept. And we are really focusing in, my presentation, will really focus on discrimination and equality vis-a-vis what we at the Equal Opportunity Commission do. And the third area is an area that I will talk about. We sometimes do a lot of these presentations for a lot of employers. So I'm going to share with you what we would normally discuss with the employer. So what can an employer do to guard against the occurrence of discrimination? Now, the Equal Opportunity Commission, I don't know how much you would have heard about this, but sometimes you might see things we might have on Facebook, on news reports and that sort of thing. We are a public body that was created by an act of parliament. We were created by the Equal Opportunity Act, and this act was passed in 2000. The act was passed to prohibit certain kinds of discrimination. It was passed to create an avenue for redress. That is, persons who felt that they were subjected to this kind of discrimination, they can claim redress. And to that end, the act created 2 institutions, the Equal Opportunity Commission and the Equal Opportunity Tribunal. We are from the Commission. Very simply, the Commission's remit with respect to complaints of discrimination, our remit is to receive complaints from members of the public. We investigate those complaints, and where possible, we try to conciliate those complaints. That is to say, we bring the parties to the table for discussion, to see whether or not you can get a resolution. That's what conciliation is. At UWI, they have classes on mediation studies. There's a postgraduate diploma, a master's and a postgraduate diploma on mediation studies. If you're familiar with anything about mediation, you'll understand that conciliation is something similar to mediation in that the conciliator or the mediator doesn't force a judgment on you. They don't adjudicate who's right or who's wrong and say, well, I find that the employer is right or the employee is right. It's really about bringing the parties to the table for a discussion. If the matter cannot be resolved, then this is where the second institution, which is the Equal Opportunity Tribunal, that is where they come in, and they are a court. So like with any proceeding before any court, you would see in newspapers about matters that are before the magistrate's court, whatever it might be, speeding tickets, that sort of thing. Or you would maybe reading about matters before the High Court. Right now, for example, we're reading about the case of these Venezuelan migrants or before a High Court judge. So as with any matter before a court, you go before a judge, you have your lawyers, or the other side has your lawyers, you present your arguments, and the judge renders a decision. So that is what the tribunal does, and as distinct to what we do. We don't render a decision and say we find you to be liable, we order you to pay X amount of dollars. It's really, if it can be resolved at discussion, which is what we are doing. We are bringing people together for discussion. If it can't be resolved there, then it goes to the tribunal, who are the court, and they can give a judgment as the case might be. The primary task of the Commission is to oversee the implementation of the Equal Opportunity Act. So we are an enforcement body, and the Act seeks to prohibit certain kinds of discrimination. With that in mind, I guess the next question, when I say the Act seeks to prohibit certain kinds of discrimination, the question would be, well, what kind of discrimination is the Act concerned about? The Act is concerned about discrimination in 4 broad categories. That is employment, and this is what we're here to talk about, education, the provision of goods and services, and the provision of accommodation. So these are the 4 broad areas that we're concerned about. And just to digress, whenever we do this presentation for employers, we always point out that you might be subject to a claim of discrimination as an employer, but also based on what you sell to the world at large, or what goods and services you provide to the world, or to the public, or to your clients, as the case might be, then you can be also subject to a claim of discrimination, or you're subject to the oversight of the Equal Opportunity Act with respect to the goods and services, with respect to how you provide your goods and services. So it's something to think about. Again, so that when you become perhaps an employer, then you would also have to think about that. Not just discrimination against your employees, but discrimination against your customers, your suppliers, that sort of thing. The Act is concerned about discrimination and the provision of accommodation. And I know for many UWI students, this is always a touchy subject. You always hear stories about persons seeking accommodation in the St. Augustine and Curragh area, having the horror stories that persons go through. So just to let you know that yes, the Equal Opportunity Act is concerned with that, and the Equal Opportunity Commission would have been able to deal with any complaints about discrimination in the provision of accommodation, and also discrimination in education. However, that discrimination must be tied to certain personal and inherent characteristics known as status. In other words, we sometimes get a lot of complaints. I'm being discriminated against, let's just say, by my lecturer, because they gave me this grade and I don't think I deserve this grade. Now, in your mind, you might think you're being discriminated against, because in your mind, you might feel that you're being treated unfairly. And perhaps it is a form of discrimination, but it is not the discrimination that the Equal Opportunity Act is concerned about and that we are concerned about. So our mandate is not to review your lecture and see why they gave you this grade. We are concerned with discrimination that is based on certain inherent characteristics known as status. And I always throw out the question, well, normally when we do the interactive sessions where we do it with a group of persons, I throw out the question to them, well, what are some of the grounds on which you could be discriminated against? You hear, for example, people say I'm being discriminated based on my race or my ethnicity. Persons say that they're being discriminated against based on their age, and that's correct. But I'll just stick a pin on age. Persons talk about discrimination based on sexual orientation, and that's also correct, but we need to stick a pin there. And I say stick a pin on age and sexual orientation because the Act is only concerned with discrimination on certain particular grounds. That is to say, there are 7 grounds they're concerned about. That is your race, your ethnicity, your religion, your marital status, your origin, your sex, and your disability, if any. So that while there might be a genuine case where someone is being discriminated against based on their age or based on their sexual orientation, Unfortunately, at this point, we are not able to treat for those complaints because we are bound by what the Act provides. We are created by an Act of Parliament, and we have to follow the mandate given to us by that Act. So that if we were to go and treat, for example, with a complaint of discrimination based on age or based on sexual orientation, we will be what, I don't know if you've ever heard such expression, but lawyers will say you're ultra vires your powers. That is to say you've exceeded your jurisdiction, your power, your remit. Part of the Commission's mandate is to make recommendations for amendments to the Equal Opportunity Act. So we have recommended that age and sexual orientation be added as status grounds for protection. But until and unless that goes before Parliament and Parliament agrees to that, because again, this is the acts of Parliament are only amended or modified by another act of Parliament. In other words, it has to go back to Parliament and they would, debate and pass the legislation accordingly. So until and unless that happens, these are the status grounds that we are concerned about. The Act is also concerned with victimization. Victimization really occurs where you're being treated adversely because you took steps to enforce your rights or protect your rights. Again, we get a lot of complaints from a lot of people who say they're being victimized by their supervisor or their manager, their employer, and they give a story, well, this happened and that happened and that happened. And again, just as with discrimination, we say, well, it could, in your mind, you're being victimized and you're probably correct, but we can only deal with victimization where that victimization is tied to certain activities that you would have done. In other words, and we're going to list it out later, you said or did certain things, and because of that, you're being treated less favorably by your employer, then you can lodge a complaint with us. So that's discrimination on the grounds of victimization. And finally, there's a third on a standalone area known as offensive behavior. I'm going to come and deal with this in a little while, but just very briefly to explain what offensive behavior is. It is akin to what exists in other countries as hate speech. You would hear in other countries that there's a thing called hate speech. Well, offensive behavior is similar to that. It is where a person says or does things in a public domain that incites hatred against persons based on things like their race, their ethnicity, their religion, their gender, that sort of thing. So if you're inciting hatred based on gender, based on race, based on religion, then if you've done that, then a person who falls within the group to which you've incited hatred against, they can lodge a complaint of offensive behavior. As I said, we'll probably come into discuss this in certain areas. Now, the Equal Opportunity Act. What is employment under the Equal Opportunity Act? It's important to understand that for different purposes, there are different definitions of employment. If, for example, you were to study, well, again, as a UWI student, I can tell you in my time, we went to Cave Hill, Barbados to do this. So I'm actually a graduate of Cave Hill, not of St. Augustine. But, in employment law, we learned concepts like master and servant. Who is an employee as opposed to who is an independent contractor? And in employment law, we learned that an employer is liable for the actions of their employees, but not the actions of their independent contractors. So that's the definition of employment for that purpose. If at all you're familiar with the jurisdiction of the industrial court, you would hear a question as to who is a worker under the Industrial Relations Act. They have a more narrow, more limited a definition of who's a worker. So for example, police officers, teachers, persons in senior management, they cannot bring a claim before the industrial courts because they are not workers under the definition of the Industrial Relations Act. So then, for example, for national insurance, you have many definitions you have different concepts of who's a worker, have they been working for X amount of months, that sort of thing. Now, the Equal Opportunity Act is concerned with prohibiting discrimination, and discrimination happens in a wide variety of areas. So because of that, the definition of employment, under the Equal Opportunity Act is very wide. For example, and I'm just reading, employment means employment under a contract of service or apprenticeship, or contract to execute any work or labor, and includes the employment of an independent contractor. So any contractor to render any sort of service. Who do you hire, for example, to clean your yard, or to bring it more in the employment context? Let's say you outsource services, and you're going to realize that in the employment world, many services, for example, cleaning services, janitorial services, these tend to be outsourced. So who do you hire to do that? Are you discriminating in your hiring practices? These are things to look at. And the Equal Opportunity Act is concerned with discrimination in your hiring practices. For example, who do you hire? Many times, lawyers will tell you if you don't hire somebody, then there's no employment relationship with that person. So that, you know, because they're not your employee, you never hire them. And that is correct, for example, perhaps for national insurance, for all of these sorts of things. If you never hire them, then you're not liable for anything for them. But many times, this is where discrimination really takes place. Discrimination takes place in the hiring process. People say that I applied for a job and I was not hired into the job, or I was shortlisted and I was interviewed, but I was not hired, or I was not shortlisted altogether. So a person who feels that they were discriminated against and not being recruited into a job can lodge a complaint with the Equal Opportunity Commission. Again, you need to remember that the discrimination we're concerned about is where that discrimination is based on your race, your ethnicity, your marital status, your geographical origin, these sorts of things. If you were not hired because you scored lower based on than the person who was hired, then that by itself may not be discrimination. Again, you would have to look into the matter even more. If they scored the other person higher because they had more qualifications or more experience than you, then that might negate, or that may, by itself may not be discrimination. So sometimes, because we have received complaints like of people saying they were discriminated against in their hiring, when we asked the employer, they produced these score sheets of the interview and said, well, Mr. So-and-so scored third, or second, and this person scored first. And then it was necessary for us, as part of our investigation, to inquire, well, why did this person score higher? Why did this person score lower? What were the questions that were asked? How did you? What were the characteristics you used to score the persons? You know, and sometimes that's where the discrimination will come about. The Equal Opportunity Act also applies to discrimination in your relations with your existing employees. For example, are you paying someone, a woman more than a man more than a woman, which is more often in the case, or it could be the other way around, a woman more than a man for doing the same job. So in other words, these are two employees that you have, and are you treating one more favorably than the other, or is someone being treated less favorably? And why is that person being treated less favorably? Now, if it is, for example, going back to the example I gave earlier, that the man has more qualifications or more experience, then you might be able to justify the differential pay there. So again, you would have to look at the reason for this differential treatment. Your relations with your existing employees would include things like, who do you send on training? Who do you give some favorable benefit to? A favorable benefit could simply be, who do you give a better parking spot to, a better office, better computer facilities? Now, if you can say that we were doing a rollout of new technology and so-and-so got an upgrade, but we ran out of funds, then perhaps that by itself may not be discriminatory, because the employer can give a genuine excuse. Well, you know, we were trying to do X, Y, and Z, we ran out of funds, we have to wait until however, we source more funds if we can't do it at all. But if you are an employee in an organization and everybody else gets something and you don't, then you are entitled to ask, well, why did I receive this less favorable treatment? Again, it's up to the employer to say, well, these are the reasons why. And it also thirdly applies to your relations with candidates who are undergoing apprenticeship or training. Again, going back to what I said earlier, these persons may not be employees in the legal sense. So for NIS purposes, for tax purposes, they may not be employees because they are apprentices or trainees. But for the purposes of the Equal Opportunity Act, they would be considered employees vis-a-vis a claim of discrimination. So again, if you have two apprentices or two trainees and one is being treated better than the other, then the other person can ask a question, why? Now, if the employer can say, well, I'm treating X better, Mr. X better, because he's showed a better work ethic. He's coming to work on time. He's not disappearing every day for lunch. He's not taking excessive sick leave and that sort of thing. Then that would be a genuine reason to justify the differential treatment. So again, it is something that we would always have to ask the question: the mere fact that there was differential treatment is not discrimination. It points to an issue that requires questioning, and upon questioning the employer can say, well, look, this person is delivering their work on time, these sorts of things. They're showing better productivity, they're putting in a better effort into their work, and hence they're getting the better treatment. Then the employer would be able to justify or to validate why they're giving more favorable treatment to that person. So that's just something to think about. Discrimination in the provision of goods and services. I'm just going to talk very quickly about this area. It means exactly what it says. In the manner in which you provide services, The examples are, for example, access and use of a public place, accommodation in a hotel or guest house, facilities for banking, loans, insurance, finance, facilities for entertainment, recreational refreshment, transport or travel, the services of any profession, trade, statutory, municipal authority. It's just something for you to know. I don't want to go in too heavily into too many different areas because I know you're going through a lot of training and a lot of, I just need for you all to know this in the event that when you graduate and say you go and work in an organization, let us say you work in a statutory or municipal body, you are working in a bank, an insurance company, a company that provides finance. So it could be so it's not just a bank, but any financial house, Island Finance, anybody who provides some sort of financing. It's just important for you to know that your organization can be subject to a claim of discrimination in the provision of goods and services. So what would discrimination be? For example, is it differential pricing? Now, differential pricing doesn't simply mean that you're running a Black Friday sale. Obviously, that's a sale that you're giving to everybody, to the world at large. Or even differential pricing to preferred customers. Let's say you have a membership, many businesses will give you a customer card, and if you've made X amount of purchases, you're entitled to higher discounts. That by itself is not discrimination. What the Equal Opportunity Act is concerned about is discrimination based on your characteristics. Are you saying, I'm going to give customers of a certain race a differential price, or I'm going to give customers of a certain religion a differential price, or I'm going to give customers who are men a different price to customers who are women? That sort of thing. That is what we're concerned about, as opposed to saying, if you've purchased $1,000 worth of goods over the last 6 months, you get a trade discount, and that sort of thing. Yes. So that's what the services of discrimination and provision of goods and services is about. I'm going to just talk about discrimination in education. And discrimination in education refers to things like refusing or failing to accept a person's application for admission on the terms on which an educational institution. And it's important to know that the Equal Opportunity Act applies. If I didn't mention this before, the Equal Opportunity Act applies to both the public sector and the private sector. So for example, when we talked about employment, it's not just a state employer or government employer. It applies to any employer out there. Similarly, when we talked about the provision of goods and services, if you use the example of banking, insurance, loans, and finance, that is predominantly a private sector driven service. Again, so the Equal Opportunity Act applies there. So similarly with education, it's not just state or government schools. It's not just primary schools or secondary schools or the UWI, which are financed or owned by the government, or where the salaries of the teachers are paid by the government. It can be any educational institution. So any private secondary school, a private tertiary school, or private primary school, they are subject to the Equal Opportunity Act. So when the Equal Opportunity Act is concerned with things like denying or limiting a student's access to benefits or facilities, or expelling the students or subjecting them to detriment. Now, if you expel a student, let's just take a typical high school example. You suspend or expel somebody because they were engaged in some undesirable behavior. They were engaged in vandalism or setting fire to the property, or that sort of thing. If the school can justify why they took that in itself is not discriminatory. Where it would be discriminatory is if, let's just say, you have a group of students who engage in same undesirable activity. One set was simply given, we're told don't do it again, but the next set was suspended. Then that by itself could be discriminatory. Now it may not be. Just to go to the flip side, it may not be discriminatory if the principal can say, well, the students who I suspended, this was their third or fourth infraction. They've been doing this repeatedly over and over again. And so that you have to move up, as I say, there's a concept known as progressive discipline. So the first time the student did it, I might have spoken to him. The second time, I might have given him detention or whatever. The third time, probably detention again. And now the student keeps doing it again. So now we have to move up the ladder to the next stage, which is a suspension of the student. So it goes to show that, you have to look at each situation on their merits, and you just can't simply say, or it isn't automatically discriminatory if the students are treated differently. So that's why I say it could be discriminatory if you have a group of students and some are treated discriminatory. It could be, but then you would have to ask for an explanation why. And if you can justify the reason why, then that would not be. Then that's clearly not a case of discrimination. with respect to secondary schools, we used to get a lot of complaints, or not a lot, but a number of complaints about persons who said, well, my child was not accepted to do, well, in my time we called it A-levels. I think it's called it K, the advanced level proficiency exam. My child was not accepted, well, I'm just referring to it as A-levels. My child was not accepted to do A-levels for these subjects. And so we'd ask the school why, and if the school can say, well, we only took in students who got grade 1s or grade 2s to do those subjects, and this child got a grade 3, then that would not be discrimination by itself, as long as the policies are applied evenly throughout the board and across the board. So in other words, if you judge a student based on their merit and their ability, so if you got a grade 3, the school is saying we're not taking in persons who got grade 3s at O levels, we're not going to use that as a basis for A levels, then that would not be discrimination by itself. Yes. And finally, I think the last area, just to talk about it, is the provision of accommodation. And a person shall not discriminate against another person on the terms on which he offers accommodation, by refusing an application or by deferring an application. Sometimes you hear stories that, if persons of a certain race go to apply for a property, they're told that, well, you'll have to check back and this and that, whereas persons of another race might be given the property right away. Things like that are what we're concerned about. So if you're being treated less favorably because of your race or that sort of thing, then that would be discrimination in the provision of accommodation. Now, I've spoken a lot about race and ethnicity. Persons tend to ask, well, is there a difference between race and ethnicity? And the short answer is that race is seen as something biological, whereas ethnicity is seen as something cultural. So race, race is determined by certain biological markers, for example, the color of your skin, the texture of your hair, the shape of your jawline, these sort of things. There's certain things that anthropologists, there's a whole study, there's a whole department in the UWI dedicated to social anthropology. As a matter of fact, the founding chairman of the Equal Opportunity Commission was Professor John Laguerre, a former professor emeritus at the UWI, whose wife, Professor Amory Busesso, was, or is, I don't know if she still is, the Dean of the Faculty of Social Sciences at the UWI, or she might have demitted office recently. Yes, so we're well versed in the subject of social and cultural anthropology here at the Commission based on this antecedents. So yes, race is seen as something biological, based on certain characteristics, whereas ethnicity is seen as social and cultural. So one would identify with certain ethnic groups based on things like your language, your cultural practices, perhaps your aesthetic traditions, like your mode of dress. I always use the example when I'm doing these presentations that persons from West Africa would all be of the African race. But however, persons may identify along ethnic lines like the Igbo, the Mandingo, the Orisha, these sorts of things. And what would distinguish them? Because they're all of the same race, but what would distinguish them are their cultural practices. For example, persons from one ethnic tribe might have different ways of dress, might have different ways of tying their headwear, might have different types of foods that they identify with, may have different practices, different observances with births, with deaths, with religion, that sort of thing. So these are the markers that determine ethnicity as opposed to race. And it's also the same thing when we look at the markers that determine sex and gender. Again, the UWI has an Institute of Gender Studies, so I mean they can speak at length. As a matter of fact, the head of the IGDS, Dr. Gabriel Hussein, has now been appointed as the vice chairman of the EOC. So I guess in time, just as because of Professor Laguerre, we became very familiar with race and ethnicity and social anthropology. I'm guessing over the next few years, because of Dr. Gabi Hussein, we'll become more familiar with gender issues and as we go along. But again, the difference between sex and gender, sex is biological, whereas gender is seen as social and cultural. So sex relates to the biological and physiological characteristics that determine male or female. And there is actually a third biological sex known as intersex. And again, this is purely biological. It's based on the things like your reproductive organs. And doctors will have a list of things that they look at to determine whether you are male, whether you're female, or whether you're intersex. Intersex, as I said, is purely biological. It's something that you're born with. Whereas gender is seen as social and cultural. Gender speaks of concepts like masculine and feminine. So that you would hear that these are the roles, these are the traditional gender roles they associate with men, with women, the gender expectations of husbands, of wives, that sort of thing. That's what gender studies is about. And again, I'm not going to go into it. And there's a whole institute at the UWI dedicated to this area. Now, religion speaks to the worship of a supreme being or a divine entity. And you have lots of different, and I think that's self-explanatory, discrimination on the basis of religion. I had mentioned earlier that there's an equal opportunity tribunal, and one of the very first cases that went to the equal opportunity tribunal was a case of a woman, a security guard, who claimed that she was discriminated against when she started wearing a hijab. So that was a claim of discrimination on the basis of religion. She was working as a security guard, and while doing that, she converted to Islam and started wearing a hijab, and her employers terminated her. And she brought a claim to the commission, which was not resolved at our level of conciliation. So it went to the court, the tribunal, and they gave a judgment in her favor. The employers used the excuse that in wearing the hijab, she violated their uniform policy. That is to say, persons who work in the security industry, they have to have uniforms that are approved by the Minister of National Security. It's a regulated industry where the Minister of National Security has to approve and grant what they call precepts to these persons, and they said, and grant authorizations to security companies to operate. And they said that the Ministry of National Security had approved a uniform, and this lady wearing a hijab had altered the uniform. But one of the questions that was asked of them was, well, did you seek guidance, or did you seek the approval of the Ministry of National Security, or did you seek any clarification from them about the wearing of a hijab? And they said no. So that the court found that this was a form of discrimination against a person who was a Muslim. Now, there are many Muslims. Now, one of the arguments that they raise is that there's nothing in the Quran that speaks specifically to the wearing of a hijab that mandates that a Muslim woman must wear a hijab. And our response to that is that religion is inherently personal. You might have a Muslim woman who does not wear a hijab, and she's no less of a Muslim person than a Muslim person who chooses to wear a hijab. It is inherently a personal choice. So the wearing of a hijab was this person's outward manifestation of their religious belief. Had they choose not to wear hijab, then you could say, well, that's also a I would say it's a manifestation of their belief to not wear hijab, but it's a manifestation of their personal choice. In the same way, a person who's a Christian may choose to wear a crucifix around their neck, a cross, and that is an outward manifestation of their belief, but they may also choose not to, and that's their choice whether or not they choose to wear a cross. And just on an aside, there were some cases from the United Kingdom a few years ago about the wearing of a cross that went to the European Court of Human Rights. One of these cases was an employee of British Airways, a stewardess, who wore a cross under a uniform. Now, British Airways had no jewelry or no policy or something of that sort. I can't remember what it was. But the European Court ruled that this was a violation of her right to freedom of religion if she wore a cross underneath, that was discreetly concealed underneath her uniform. Now, another case that went in the same batch was that of a lady who was a nurse in a psychiatric hospital. Now, this was a hospital, not just a psychiatric hospital, but a hospital for persons who were criminally insane. That is to say, they were found guilty of crimes by the courts, but they were sent to what we would call an insane asylum, because they were. A lawyer would explain to you that there's a concept of not guilty by reason of insanity, or concept of guilty but insane. The Americans use the words not guilty by reason of insanity. We follow the British rubric, which was guilty but insane, and both really mean the same thing. That because of your mental disease, you ought to be treated in an asylum rather than be sent to prison. Now, this lady was a nurse working there, and the hospital did a review of the uniform policy, and they based on this audit, they found that if persons wearing any form of neckwear, any form of chains, could be subject to attacks by these inmates, because these were violently insane persons. So the person can use this chain to strangle them, to choke them, to grab them, that sort of thing. And because of that, they implemented a policy of no neckwear. And they were very specific with how the persons would have head ties and all of these sorts of things. And it was based on what they called safety requirements. And so that person also went to the European Court of Human Rights, and the European Court of Human Rights ruled that the safety requirements of the job trumped her religious freedom. So whereas in the British Airways case, British Airways just simply said it was a uniform policy, or a policy about their dress, but they were not able to point to any safety requirements or anything that had to do with, managing an airline in the event of a crash. It was just a uniform, it was just a dress requirement. But the person who was working in the criminal asylum was able to, in that case, sorry, her employers, not her, but her employers were able to show that it had to do with safety and health and safety at work. And so that's just something to think about religion. That although you are entitled to your freedom of religion, if there's a health and safety issue, then health and safety trumps, this religious freedom. Now, origin, the Equal Opportunity Act is concerned about origin, including geographical origin. Many times we get complaints, or we hear, complaints, persons who say that if they originate from certain geographical areas in Trinidad, they have to hide this on the applications. They feel that once an employer hears that they come from, say, Enterprise or from Laventille or one of these areas that are traditionally associated as economically depressed areas, as crime hotspots, they feel stigmatized by that. So they feel that that either the employer will hold that against them or not hire them, and in some cases we've actually had an experience where someone applied for a job by us and they put a post office box as their address. They had a post office box. So it's just something to think about. How do you view persons? Maybe how you are viewed, and if you again become an employer or supervisor, manager, how do you view persons who come from certain geographical areas? But origin, it says, includes geographical origin. And so it's not only that. We have interpreted it to mean, or very simply the dictionary meaning, origin means where do you come from. So it could mean your ancestry or your parentage. For example, there's one case that we have referred to the Equal Opportunity Tribunal where a person said that they were denied participation in an event in a sports day. And they were told, this is their version, the person who organized the event denied this, but this is their allegation. Their allegation is that they were told, well, we don't want you here because of who your father was. Your father was someone who had a very, let's just say his father had a very difficult relationship with that organization. And, I'm not going to go into it, but that would be discrimination based on your origin if you say, the reason why you are not wanted here or when they hire you is because of who your parents are or who your ancestry, your background, that sort of thing. So that's something to think about. I'm not going, well, marital status is self-explanatory, and I have spoken about sex. So I had mentioned intersex, which is, as I said, is a biological condition where a person is born with both male and female characteristics. So we say that there are 3 biological sexes: male, which is female, and intersex, which are, and again, these are things that are defined by doctors. It's not, a doctor would say based on that. And this is an interesting slide. We also say that what makes up the totality of a person. There is their natal sex, which is what they're born with. There is their gender, and their sexual orientation. So, but we also point this out to you to know that they're not necessarily the same thing. I mean, they all contribute to a person's identity, but we ought not to necessarily confuse biological sex with gender and with sexual orientation. Gender, for example, and again, if one were to go to the IGDS, they will tell you that gender is seen as a fluid construct, and that persons can choose a gender identity different to their natal sex. And it is something for you to think about, if only because you as an employee might come across a co-worker who identifies with a gender different to their natal sex, to their biological sex. And how would you, as a co-worker, treat with that employee? How would you treat with your co-worker? I'm mixing up the terms, but as a co-worker, how would you treat with your co-worker who identifies differently to their biological sex? Or how would you treat with a co-worker whose sexual orientation might be different to yours? We say that there are a number of different sexual orientations. There's heterosexual, there's homosexual, there's bisexual, and again, IGDS can speak to great length about the research into this area. So something for you to think about. Now, the Equal Opportunity Act is concerned about sex, and as I said, sex speaks to biologically, male biologically, female biologically, intersex. But I'm just throwing this out to you for you to think about in terms of how do you treat with persons in the workplace whose gender might be different, to their sex, or whose sexual orientation might be different to yours. Yes. And disability. Now, disability, the definition under the Equal Opportunity Act, we always say it's a bit old-fashioned. It uses words from the 19th century. It speaks about a malformation or disfigurement or what have you. But one of the things about the definition, if you look at C, a malfunction of part of the body, including a mental or psychological disease or disorder. Now, I say that because everyone, I think, can understand the concept of physical disability. A person is an amputee, a person uses a wheelchair, a person uses crutches, they have some part of their body that's missing or malformed or not fully functional. So we see that those are the things that we see, and in our minds we can grapple with that as a disability. But we don't ever really think of psychological diseases or impairments or disorders as being as forming a disability as well. So a person who has paranoid schizophrenia, a person who has bipolar disorder, they also have a disability. It's not the physical disability, but it is what you call the hidden disabilities. And I say that I mention this because of just as some food for thought. When we do sessions like this for a lot of employers, we just ask them, well, what is your disability policy? And they will say, well, we have accessible bathrooms, bathrooms that have the wide doors. We have wheelchair ramps, that's, grab bars, that sort of thing. And that's fine. That's good for treating with the physical disabilities. But how then will you treat an employee, or if you're an employer, if you were an employee, how would you treat a co-worker who shows signs of manic depression, of bipolarity, that sort of thing? It's something for you to think about. And according to Professor Hutchinson, while the burden or stigma falls on those with mental health problems, it's created by the attitudes of the wider society. It has been theorized that stigma against others is created to reaffirm one prefers identity. So it's really an attitudinal issue. In disability studies, we speak about the social model of disability. And the social model really looks at the persons are disabled, not because of their physical characteristics, but because of societal barriers and attitudes that they face. So 100 years ago, 200 years ago, a person with visual impairments might have been disabled. But now, everyone has eyeglasses and contact lenses and these sorts of things. So that is no longer considered a disability. You can't say I'm disabled because I wear eyeglasses, but maybe 200 years ago you could have. So in other words, that's just an example of where the attitudinal barriers and the societal barriers have been eliminated with respect to the wearing of eyeglasses. So it's just something but again, 200 years ago, that would not have been the case. But so that's really just to throw out to you that disability is not just the characteristics of the person, but the attitudinal barriers that they face and the physical barriers that they face. Because as I said, now the wearing of eyeglasses presents absolutely no barriers, and no one can claim disability because they have 20/18 or vision or 20/60. Well, however vision is characterized by an optometrist, that they don't have 20/20 vision. I don't want to confuse 20/20 vision with the year 2020 we're in. Did you know 1 in 4 persons is affected by mental illness? The most commonly diagnosed illnesses in Trinidad are schizophrenia, mood disorders, and that sort of thing. And just as a finally on this area, how do you treat the persons with disabilities? In the past, we spoke about disabled persons, that is disabled and disabled persons come after. But now, the Trinidad and Tobago has signed on to the United Nations Conventions on the Rights of Persons with Disabilities. That was in 2004. And the language coming out of that convention is that you say persons with disabilities, PWDs. The thinking is that you put the person first. You recognize that they're first and foremost a person when their disability comes after. In the study of linguistics, you know that language is dynamic and it's always changing. So you say a person with disability, a person with epilepsy, a person with bipolarity, as opposed to a disabled person. And yes, now if you want to know more about disabilities, the Commission has published guidelines for employers and disabilities in Trinidad and Tobago, so I'm not going to go into this at all. It's available. All of our guidelines are available for download on our website. And I'm just very briefly going to touch on the area of sexual harassment. Because I've spoken about victimization already, so I'm not going to go into that because I know we're running out of time. On offensive behavior, I mean, the slides are there, so you can look at it. We also publish guidelines for employers in Trinidad and Tobago so that What we like to say is that your recruitment practices should not be based on the status of an employee. So, for example, we see male employees, if you look at a slide, male employees needed for a plant shop. Now, it may be that they need male employees to do heavy lifting, lifting large plants and bags of soil and large pots and what have you. But the ad in itself is discriminatory because the ad just says male. What you need to look at are what are the requirements of the job. So, for example, if you look at one to the center, experienced hairdresser must be able to do braiding, weaving, hairstyling. Again, you look at what the requirements. You didn't say male, you didn't say female. These are things we just picked out of the classified ads, but I thought it was a useful, example of what we mean by saying, by focusing on the requirements of the job. This is what you need to do. And finally, I'm going to touch on just for a few minutes before I close off, is sexual harassment in the workplace. And we have published guidelines on sexual harassment as well. So those are the 3 guidelines we published that are available for download on our website. Sexual harassment is any unwelcome advance of a sexual nature that makes a person feel offended, humiliated, or intimidated, where a reasonable person would feel that in the circumstances. And there are generally two types of situations, what we call the quid pro quo. You heard that word a number of months ago, Donald Trump famously speaking about quid pro quo. And it just means, it's a Latin expression, it means something for something. In other words, if you want a promotion, if you want a better job, if you want to go on training, if you want a higher salary, then you have to submit to sexual favors, something for something. But there's also a second area known as a hostile work environment, where the environment is so charged because you're going into, it's normally women who would claim this, but you're going into an environment that's filled with pornographic images, that sort of thing. And you feel intimidated, you feel excluded from the environment because of its hostility. It's not just a matter of feeling uncomfortable, but it has to be a hostile work environment that you cannot be expected reasonably to perform your job comfortably in this environment. One thing we also say is sexual harassment is not just limited to male and female dynamic. It could be a female harassing a male, and it could be a person of the same sex. It could be a male harassing a male, or it could be a female harassing a female. And we speak about sexual harassment in the world of work as opposed to sexual harassment at the office or the workplace, because the thinking is that sexual harassment sometimes happens not just in the office, but it can happen outside of the office. You tell this person, come, let's go out for lunch. And, and it's there that the proposition takes place. Persons go abroad to a conference, or they go to a training facility outside of the office. So it's work-related, and also work-related social activities. So that's why we say, that's why the language is sexual harassment in the world of work, as opposed to sexual harassment in the office. So there's something to think about as for you to be aware of. I'm not going to go into all of these areas. I think the slides are there. And it's all part of our, it's all part of our guidelines on sexual harassment in the office. So with this in mind, I think I know I've spoken for quite some time, and I think I now open the floor to questions and comments.
Thank you so much, Haran. Really interesting information that you shared with us. And, we do have a few questions from the students. So while we put those together, I actually do have a few questions myself that kind of came up while you were speaking. And one of the things that I was wondering is, how difficult is it to establish discrimination in the workplace? I doubt people would sort of openly admit to being racist or, misogynistic or what, that type of thing. So how is it that, how difficult is it to establish when somebody probably senses or maybe feels like, I think I'm being discriminated against?
It is somewhat difficult, but it's not impossible. For example, one case that we had that went to the tribunal, this was a case of race discrimination. I mean, I can talk about the judgment because all judgments of the tribunal, just like judgments of the High Court, are public matters. This was an employee of WASA who said that he was acting as an IT manager in his department, or whatever it was. I can't remember the exact name, but let's just call it the IT manager. But he did not have a degree. And WASA said, well, and so another employee he was of African origin, another employee of East Indian origin, said, well, look, I have this degree, therefore I should be made to act instead of him because he doesn't meet the qualifications. So WASA removes the person who didn't have the degree and put the person who did. Now, the person who didn't have the degree went and did some research on the other person and found out that the degree that they presented was from an online paper mill. He actually got a report from the Accreditation Council that said that this degree is not recognized as not valid. And when he actually presented this document from the Accreditation Council to WASA, they did not remove the other person from the job. So he brought a claim with us for race discrimination. It's interesting because he only had what, in normally discrimination cases, you need to have what is called a comparator, normally. In other words, you are comparing yourself, because the essence of discrimination is not just I was treated badly, but the essence is that I was treated unfairly compared to other persons, or at least one other person. And he just had one other person to compare himself to. And he was actually able to succeed at the tribunal. And one of the bases on which he succeeded was that it was clear that WASA removed him from the job because he didn't have the qualification, and that's fine. But when WASA became aware that this second person did not also have the qualification, they did not take any steps to remove that person. So the burden now was now thrown on, so that by itself is not discrimination, but the burden was now thrown on WASA to say, well, could you explain why? Because again, you would notice when I've spoken all the time, we always go back to the person, to the employer, to whoever, to say, well, could you explain why? And WASA could not explain why. So the court made the inference, well, if you can't explain why, then it's obviously, we will make the inference that there was a case of discrimination taking place here. So it's not impossible. But one of the things, as I said, you would need to be able to look at is, one, do you have a comparator, somebody who you can compare yourself to? And two, can you explain the reasons for this differential treatment? And in the case of that man, Kerwin Simmons, actually all judgments of the tribunal are available on their website. They have a website as well. So it's a public matter, as we say. As judgments of the High Court are public judgments. These are public matters. Anyone can look at it. Kerwin Simmons against WASA. One, he had this person who he compared himself to, and two, a burden or responsibility on owners rather shifted onto WASA to say, or the employer, can you explain this differential treatment? And they were not able to point or to give any valid reason to explain why he was treated differently.
Okay, awesome. So one of the questions coming from a student is, they're asking about being told about inappropriate hairstyle during an interview. I'm thinking this is during a job interview.
Yes.
And, I don't know if you could speak to that in terms of what does that look like? Yeah.
Well, we've received a number of complaints like that, and they normally fall within complaints of ethnic discrimination. Because again, we said your hairstyle. There's nothing that it's not necessarily race discrimination. It's more ethnic discrimination, because the way, for example, a person of African origin or Afro-descendant person who chooses to wear what you call a more natural hairstyle, that's again, that's seen as ethnicity rather than race. One of the things we look at is what are the reasons for the employer saying these things. Now, I had mentioned about health and safety. There were cases in Canada and in the United Kingdom of persons who were of Sikh origin. These are the persons from India who wear turbans and have long beards, were told, if you have to work in a restaurant, you need to present a more neat and trim appearance. When those persons took them to court, the employers, the restaurant owners were able to say, there's a hygienic stigma attached to long bushy beards, and persons may not feel comfortable being served by someone, with a long bushy beard. I mean, when it says food to eat, it's not a market vendor on the side of the road. You're buying, cucumbers, and you can come and wash it. I mean, this is actual food. And the restaurant owners were able to succeed in their defense. So in other words, you would have to look. It's not an automatic case to say that that a hairstyle or a beard being told about it is discrimination. You would have to look at what that person is being hired to do. If they're being hired, for example, to work in a service industry, they may be told not necessarily that your hairstyle is wrong, but that you perhaps need to be neater, or your beard needs to be trimmed, or something of that sort, because of service standard requirements. So it's always, again, a case of saying, let's hear the other side. But if there are no service standard requirements, then it could be a form of discrimination. But as we say with a lot of people, you have to lodge a complaint, and we would have to investigate it and ask the employer, well, what are the reasons for you saying this?
Right. So I guess, we've had situations where it's even reached the news where people hairstyles were issue with where they worked. And I'm kind of wondering, where do you sort of like draw the line in terms of discrimination and organizational culture? Because like we know certain industries are very conservative, like for example banking and finance, and we have industries like the cultural and creative
Yes.
industries where you could come to work with a tattoo sleeve
Right.
and you could have locks down to your waist and nobody's going to really tell you anything. So I don't know, where does that line get drawn in terms of discrimination, what's appropriate and what's professional, what's
Yes.
considered professional.
Well, to begin with, standards are changing over time. But again, I mean, there's hygiene, there's health and safety. Let's just say you're working in an industrial plant in Point Lisas, and you have to wear headwear and breathing and masks and these sorts of things. They may say, well, if you have dreadlocks or if you have a long beard, yeah, then we kind of fit these masks onto you. Um, Actually, right now we have a case that's referred to the tribunal with the fire service of Trinidad and Tobago. A person, and, those are very regulated sectors, and they have regulations going back to the 1920s or 30s that said that actually speak to how long, if a fireman has a mustache or a beard, how long it should be. And this person claimed to have changed religions, and their religions prohibited them from shaving. So at least at the tribunal, when they adjudicate on that, we might have a judgment as to what are the limits or what are the frontiers of saying that of personal expression, because I guess your hairstyle or your beard is personal expression, as opposed to what is professional. Now in the fire service, they were relying on your ability to fit into masks and what have you. But the person was saying that if I wear this type, the balaclava mask or something over my face, the one that just has your eyes and nose out, then I can fit the headpiece on. So that's something to look at. But it is true. It is an evolving area, and it's pretty difficult to say what are the boundaries between personal expression and being professional.
So an organization does have the right to have, say, like like how HR would have their rules and regulations in terms of dress code and that type of thing. An organization has that right to sort of outline what they determine to be professional dress code in their workplace.
Yeah, they would have that right. Let's just say a person has a temporary medical condition, then the organization would have to accommodate that medical condition if it's not going to provide a health and safety issue. So if it's just simply HR wants persons to look a certain way, as opposed to saying that you're working in an industrial plant and you have to be clean shaven to fit into the mask, then that's different. I mean, and you say, well, I have a medical condition where I can't shave, then they may not be able to accommodate you. But if you're working, let's just say in an office-based environment, because there is a duty of an employer known as reasonable accommodation, that they have to do what they reasonably can to accommodate you, and there's no fixed standard as to what is reasonable. What is reasonable? I always use the example. Let us say you have a person who uses a wheelchair. It may not be possible for an oil company to accommodate them in one of their platforms in Galeota. Well, let's just say they have an office building. In an office building, they might be able to accommodate the person there. So there's no fixed standard to say. I'm just using an example. Let's just say there's no fixed standard to say BP cannot accommodate this person. They may not be able to accommodate you in one place, but they might be able to accommodate you somewhere else. So there's no uniform standard really. It has to do with the and again, what BP may be able to do. I'm just making them up as an example. Let us say you're a small entrepreneur now starting up a business. If you have let's say a shop somewhere in one of those sidewalk malls, those malls, those kind of Voyager type malls where you have small stores in the middle, and you have a cramped place, you may not be able to accommodate, and someone applies to a vacant job there. If that person, you may not be able to accommodate that person who uses a wheelchair. If your physical layout, you can't physically accommodate them. Whereas an institution like say the UWI or that has large offices and a big sprawling campus in St. Augustine, it might be easier for them to accommodate. So there's no one size fits all. So what is accommodation? You have to look at the nature of the job, the size of the organization, that sort of thing.
Right. So in your presentation, you spoke about, rights in terms of like trainees and apprentices. We have a question from a student asking how would it be applicable for an intern who is only contracted for a short period, so like maybe a vacation intern, just working for like the vacation period or just a couple of months. Do they have access to seeking regress if they feel like they've been discriminated
Yes,
against
yeah,
or
yes,
victim of?
yes. I mean, they can. From a practical point of view, I'm just using this practically. I mean, our investigation and conciliation process is not an overnight process. So by the time this comes up, you would have left the organization, but there's nothing preventing you from seeking that redress. I mean, if you feel you were discriminated against, then you can lodge a complaint with us. As I said, it's not an overnight process. By the time, it might take a few months, and by that time, your apprenticeship might have come to an end. But that is in itself is not a bar to you lodging a complaint with us.
Okay. And, one of the things we always tell students, that they should not include their photograph if they're, on their resume or anything like that. And one of the questions we actually have here is, what about employers that request a photograph as part of the application? You met all the qualifications and required experience, but was never called for the interview. So maybe they asked for the photograph.
Yes.
Yeah. I don't know.
Yes, we've gotten that question a few times. Now you use the example to create it. Unless you're in the creative sector, then obviously if you're a model or something like that, they'd want to see what you look like. If it is, and to that extent, I know that there's, like, for example, in the US, there was a store called Abercrombie and Fitch. They were regularly cited by the US anti-discrimination authorities. They've had matters that went to the Supreme Court because of their discriminatory employment practices, where they only hired persons who looked a certain way. They want persons that, I guess to some extent you could in a roundabout way log them with the creatives as well, and that they want persons who look a certain way to market their products. But ordinarily no one, unless there's a reason that's tied to, for example, modeling. There's no reason for an employer to ask for your photograph with the application form. We've gotten a lot of complaints like that. The unfortunate reality is that you can only lodge a complaint after the fact. In other words, if it is you didn't send the photograph and you were not shortlisted for an interview, I mean, you can lodge a complaint based on that. But there's no legal compulsion and there's no right of an employer to ask for your photograph, unless, as I said, it has to do with something in the creative sector where they're looking for a model or looking for someone with physical characteristics.
Right. And I mean, just in terms of the hiring process, because I feel like, if you're in an organization, you probably have reoccurring experiences that kind of making you think, okay, this doesn't feel right. Let me see if I can lodge a complaint or talk to somebody in HR, etc. And I'm just wondering, in terms of the hiring process, since you're not really part of the organization, but you feel like maybe you were discriminated against because you had the qualifications, and maybe talking to other people who applied and you hear some people got called for interviews and you didn't get called for an interview. How would you, is that a wise thing to do? Maybe you sort of flag yourself or blacklist yourself as being a troublemaker, and then the organization may not ever want to hire you for any other opportunity. Yeah.
Well, it's a toss-up that you would have to make. Anybody who lodges a complaint, there's always a toss-up you would have to make. Now, we do have an area, as I said, known as victimization, where, let us say you lodge a complaint with us, and having lodged a complaint, you are now blacklisted by that employer. Then you can lodge a next complaint known as victimization to say that you're being victimized. But again, as you rightly pointed out, there's always a toss-up as to whether or not you want to go down that road. But more often than not, a lot of employees do that. So let's just say the employee lodge a complaint with us about something, and thereafter they notice that they're being excluded from projects. They were excluded from a training program, that sort of thing. Then we have received a second complaint from that employees of victimization. So the victimization is really where you're treated adversely or less favorably because you've lodged a complaint or because you've supported a coworker who lodged a complaint or did that sort of thing. So there is an avenue for getting redress, but as you pointed out, it's really for the individual to decide whether or not they would want to go down that road altogether.
And in your view, I mean, do you think at the end of the day, it's worth sort of just based on your experience and, you know, having received different complaints over the years, do you think it's worth the, you know, people standing up for their rights and, you know, making that complaints?
I would always say that, yes, there is an intrinsic value to you standing up for your rights. To use the local expression, you know, if an ant bites you, I mean, I wouldn't recommend that you complain about some things that might be minor or frivolous, because the reality of working, and I don't want to use the word minor or frivolous in a pejorative way, but the reality of any working environment is that sometimes there might be things that we may not always agree with, or we may not always see eye to eye with our supervisor or peers. And that's just the reality of working with people generally when you go into a working environment. But I think, yes, if you are being discriminated against, it is something you ought to pursue. We always recommend, though, that your first line of pursuit should be with your employer, with your human resource department. That you should go to, rather than come to us first, you should always go to them first, because, you know, we also receive a lot of persons who call in or who walk in or who may lodge complaints, and then we would ask them, well, did you raise this with your employer first and foremost? And they said no, and we said, you know, perhaps you should try that avenue first, exhaust that, and then you can come to us if you're not getting the redress that you want.
Yeah, I think sometimes people sort of escalated to the highest person too quickly without sort of like going through, you know, maybe your immediate supervisor, if that is not the person with the problem. And then you just sort of like, you know, go through the different steps. A common term that I hear a lot in the news, I don't know if we have a similar thing. You hear a lot about like whistleblowers and whistleblowing legislation or protections. I don't know if you could speak more to that and if we have something similar.
Well, whistleblowing in the US really related to persons who blew the whistle, for example, on financial practices, on maladministration, on corruption, that sort of thing. We have no legislation like that in Trinidad and Tobago. The Equal Opportunity Act gives you some whistleblowing protection with respect to discrimination issues. So, for example, if you are seeing discrimination in the organization against persons of a race or religion, then you can whistleblow, for want of a better word, under the Equal Opportunity Act. But with respect to that issue, you can't really whistleblow under the Equal Opportunity Act for, like, you know, what they did in the US, where they were cooking their books, as they say, they were, you know, overvaluing their assets, financial fraud. Because I think most of the whistleblowing in the US had to do really with financial fraud, that sort of thing. So no, there's no legislation in Trinidad for that kind of whistleblowing. Now, as I said, we have said that sexual harassment is a form of sex-based discrimination. So again, if you whistleblow on sexual harassment under the Equal Opportunity Act, yes, so in other words, you can whistleblow, for want of a better word. So what fits into the Equal Opportunity Act? But like I said, financial fraud and, like what I said recently, or was it Volkswagen had, lied about, reports, that
emissions,
kind of thing. Emissions, yes. There's no legislation in Trinidad and Tobago whistleblowing on that.
Okay. So we had a follow-up question from the previous one. A student was asking if you brought up your issue, your grievance with your employer in terms of, discrimination or victimization or whatever the issue is, and there's nothing is done. Mm-hmm. I guess they're asking what next. So you've made that first, opening and said something.
Okay, I guess, you would have to look and see if there's a grievance policy. So that's, for example, if you've, made a report and nothing has happened, so the next step, I guess, would be to escalate it according to the grievance policy. There is one. Or if there isn't one, I guess you can escalate it within the organization according to its natural progression. So let's just say let's just use an organizational context. You speak to your manager, then you speak to HR, then I guess you can write to the CEO. I'm just using this as an example to show how you can escalate it within the organization. The HR manager, the CEO, as the case might be, about the problem if it's not being resolved. Many organizations are unionized, so you could always enlist the help of a trade union to have a grievance meeting. But again, there are some organizations, again, we have said that certain staff aren't really part of a union. And then I guess there are always external agencies you can rely on. People tend to go to an attorney to write a letter. You can come to the Equal Opportunity Commission. But again, we always say that, you try and use the grievance process within the organization. And if you're not getting results at one level, try and escalate it to the other level and see, before going outside.
Right. And once you've sort of done what you could do within the organization, and the next step is to come to you guys and you lodge that complaint. I have a question here where they're asking, how long does it take to get a response after lodging a complaint?
All right. Well, a response in terms of the acknowledging the complaint and meeting with the complainant, that's fairly quickly. I mean, we tend to move fairly quickly. Within 2 weeks or so, a week or 2 weeks, within a week, we contact you when we schedule a meeting with you. We are empowered under the Equal Opportunity Act to send a notice in writing, or basically a letter to the employer, whoever, requesting that they provide us with certain information in response. And if they do not provide us, we can actually prosecute them for a criminal offense of non-compliance. So there is some teeth attached to it. It's not just a letter that we're writing, could you please be kind enough to do this? I mean, although we're polite in the letter, we do have the big stick power behind it. And that is a process that might take some time, because, for example, whenever we write to someone, we normally give them 1 month in which to reply, because while we are dealing with your complaint, we are not your agent or your advocate. So we're not here to badger the employer on your behalf. So we have to be fair. We are a public body, so we must be guided by principles of natural justice and fairness. So we have to give the person at least a month to reply. And if the person comes back and says, it's a lot of information, I've not been able to deal with this. For example, we know in the December period, a lot of people are going to say, well, we'd like an extension. Then, we would grant an extension accordingly. So it's a process that realistically could drag on for a number of months. We do look, for example, at the age of our matters. I mean, the bulk of our matters are less than 12 months old. So that the bulk of the complaints that we're handling are less than 12 months old. But some matters could drag on for a number of months. And sometimes the delay we encounter in a matter, after we get information from the employer, we would now call the person into a meeting to discuss with them. Well, we wrote to your employer and they said so and so. And sometimes the delay we receive is at that stage, because we would call you, let's just say we call you into a meeting to say we wrote to you. I'm just using you as an example. And this is what it said, but then you take 2 months to come in, or you can't come in, or I'm busy, or I'm this, or I'm that, or the other. So sometimes the delays might actually be on your end rather than on our end,
Right, understood. I mean, really, really interesting topic. It could be a bit intimidating, just thinking about, a lot of people, at least my experience has been, a lot of people, they tend to have a fear of standing up for their rights. But I mean, having the EOC, having this commission, I think, it sort of improves workplace culture and encourages a workplace that thinks about everybody and all the diversity and differences, like you were talking about hidden disabilities, which, I think really interesting. And, I'm just wondering, in terms of the employee, sometimes people don't want to talk about their hidden disabilities because there's stigma attached to it. So, but then there might be, I don't know how to put it, but there might be situations or circumstances where those hidden disabilities are creating challenges, and then the workplace may not understand that. So, I mean, I don't know how, obviously.
Yeah, the thing about it is that if you have a disability, and it could be physical or hidden, you have to actually discuss that with the employer, because I spoke about reasonable accommodation, but the employer cannot make reasonable accommodation if you don't share with them what your condition is. Like we had a video, one of the videos we had used with our slideshow some time ago, where someone says, well, they have diabetes, and because of that, they need breaks at certain points to take their insulin. So they would need to discuss that with the employer, that I need a 10-minute break every 4 hours, or whatever the case might be, in order to take my medication. Whatever medication is, not just diabetes, as the case might be, but you would need to discuss that with your employer. Similarly, if you were diagnosed with bipolar disorder, you would need to discuss that with the employer. there's a case that we sent to the tribunal where the person actually told the employer, look, I need to time off every so often to attend to the mental health clinic that they were with. So these are little things that the person would have to discuss with the employer for the employer to be able to make reasonable accommodation. And reasonable accommodation doesn't mean an employer has to give you free time off. I mean, if you need days off on end, the employer might say, well, you would have, okay, we can work around it, but you apply for it, or you may have to work extra hours, that sort of thing. I mean, it doesn't reasonable accommodation doesn't necessarily mean unlimited time off to do what you want to do, but it does. So that's why we say reasonable accommodation as opposed to accommodation. The employer might discuss with you, okay, if it is you need these breaks, how can we work around it? Can you take one break during your lunch hour? Can you take another break here? That sort of thing. But at the very least, yes, you would have needed to have discussed this with the employer before the employer can be expected to do anything about it.
Okay. All right. Just one thing kind of is unusual, but one thing popped up in my head in terms of the types of groups that sort of have access to rights, and I was wondering about like criminal records. I mean, and the hiring process again. Does that? I mean, most people would want.
Yeah.
Does that get covered as well?
No, because we actually had a complaint like that in the past.
Right.
In the United Kingdom, for example, there's a thing known as spent convictions, where depending on the nature of the offense, I mean, obviously, if it's very serious things like murder and that sort of thing, it's not going to happen. But let's just say for more minor offenses, if upon release, a number of years have passed and you've not had repeat offenses, and the conviction is erased from your criminal record. We don't have that legislation in Trinidad and Tobago. So unfortunately, if you go for a police certificate of character and you've had previous offenses, you would have to list that in the certificate. So it's not covered really in Trinidad and Tobago. Because, but for it to be covered, there has to be legislation that actually allows you to cover it, and we don't have that.
Okay. And I mean, we're just kind of wrapping up now. I don't know if we have any more questions. I'm not seeing anything coming in, but just to let students know how they can contact your organization, where they could get more information. I don't know if you could share that.
Yes, we are based on Manic Street in Chaguanas. We have our website, www.eoc, equal opportunity. We always say it's equal opportunity, not equal opportunities. So people tend to pluralize us, but no, we're singular. So it's one word, equalopportunity.gov.tt. And that, we're actually in the process of upgrading our website. So it's a brand new website. And you can get a lot of information there. As I said, all of the handbooks that I had mentioned there, I mentioned the 3 of them, handbooks for employers, handbook on disability, and handbook on sexual harassment, are available for free download on our website. So you can go there and you can lodge complaints using the website, and you can get all of our telephone numbers and email addresses on the website.
Right. So guys, good information on their website. You know where to reach out to get more information. We have our evaluation. We put the link in the chat, and we really appreciate your feedback. If you all could just take a few minutes, it won't take too long. If you can fill out the evaluation, we really appreciate that. And thank you guys so much for coming out. Great questions, informative presentation. And yeah, that's it. Thank you so much, Haran, for taking the time out. We really appreciate it.
Yes, and thank you for having us. Yes.